Ma'am, you need to either pay your bill or leave the
I am
restaurant now.
not paying for food that was overcooked and terrible. I have rights.
You can.
This is Patricia Sue Galloway, a 61-year-old Murfreesboro woman who is about to learn that a mostly eaten ribeye is not a disputed order. Her freedom ends before this footage does.
Ma'am, you need to either pay your bill or leave the
I
restaurant
am
now.
not paying for food that was overcooked and terrible. I have rights.
You can.
40 minutes. That was how long Patricia Sue Galloway had been sitting at table 14, arms crossed, refusing to pay, after eating 2/3 of a 12-ounce ribeye and most of a 4-item appetizer basket. By the time a Rutherford County deputy stepped through the front doors of the Texas Roadhouse on Old Fort Parkway in Murfreesboro, Tennessee, the manager had already offered her a free replacement, then 50% off, then a polite path out of the building. She had refused every one of them. What she did in the next 9 minutes would turn a routine restaurant dispute into a 3-count criminal case, a viral live stream, and a police report in which an 8-ounce remnant of medium-rare ribeye was formally labeled Exhibit A. Quick question before we get into this one. Have you ever watched somebody at a restaurant work themselves into a corner so deep there was no way out, and you just sat there with your fork frozen halfway to your mouth? Tell me about it in the comments. And if you are new here, hit that subscribe button. We cover the cases nobody else slows down to explain every single week. Patricia Sue Galloway was born in the summer of 1963 in a small brick hospital just off Church Street in Murfreesboro, Tennessee. Her father, Raymond Galloway, was a long-haul driver for a regional freight company that ran routes between Nashville and Atlanta. Her mother, Earlene, worked the lunch counter at a Woolworth in the old downtown square until the store closed in 1993. The Galloways lived in a modest 2-bedroom ranch on the north side of town, on a street where every front yard had the same shade of fescue, and every garage held a project car in some stage of disassembly. Patricia grew up an only child. By every account from the relatives still willing to speak to her, she was an indulged one. She attended Riverdale High School on the east side of town and graduated in the spring of 1981. Her yearbook entry listed her ambition as marrying well and her senior superlative as most likely to argue with a teacher. Both of those would prove prophetic. After a single semester at Middle Tennessee State University, where she enrolled in a general studies program and dropped out, citing what she described in a letter to the registrar as a profound personality conflict with the freshman composition instructor, she returned home and took a job at the front desk of a real estate office on Memorial Boulevard. In 1984, at the age of 21, Patricia married Daniel Hollis Pruitt, a HVAC technician 5 years her senior, in a small church ceremony attended by roughly 40 guests. The marriage produced 2 children, a son named Travis in 1986 and a daughter named Brittany in 1989, and lasted 17 years before ending in a contested divorce in 2001. The court file from the Rutherford County Chancery Court would later become public record. Daniel cited what he described as a sustained pattern of public confrontations with retail clerks, restaurant staff, neighbors, and on 3 separate occasions Little League umpires. Patricia cited emotional cruelty and what she called his refusal to back her up in front of strangers. The judge granted the divorce, divided the assets, and went home for the weekend. For the next 23 years, Patricia Galloway lived alone in a 3-bedroom ranch on a cul-de-sac in the Three Rivers subdivision, supported in part by a modest alimony arrangement that ended in 2011, and in part by a small inheritance from her mother, who died of complications from emphysema in 2008. She worked intermittently as a receptionist at a small chiropractic clinic, as a part-time greeter at a furniture showroom, and most recently between 2018 and 2022 as a customer service representative at a regional call center that handled insurance claim inquiries. That last job ended after what the company's human resources file described as a documented pattern of escalation with callers, 6 formal complaints in 14 months, and an incident in which she told a recently widowed policyholder that he was, quote, looking for sympathy in the wrong place. By the time she walked into the Texas Roadhouse on the evening of August 17, 2024, Patricia was 61 years old, unemployed, drawing a small amount from a Roth IRA she had opened in 1997, and increasingly known to the local business community on Old Fort Parkway and along Medical Center Parkway as someone whose visits required, in the words of one general manager at a nearby chain restaurant, a designated point of contact and a corporate incident form, pre-filled and ready to print. She had been formally trespassed in writing from a Cracker Barrel on South Church Street in 2022 after refusing to pay for a meal she described as inedible, despite having consumed all of the biscuits and most of the gravy. She had been removed from an Olive Garden on Medical Center Parkway in 2023 after a verbal altercation with a server over the temperature of a bowl of soup that the server, on the manager's instruction, had already replaced twice. Neither incident had resulted in criminal charges. Both had been logged. Patricia had moved on to the next restaurant on the Strip. Her adult children, Travis and Brittany, had each in their own way drifted into a low-contact arrangement with their mother by their late 20s. Travis lived in Knoxville and worked as a parts manager at a Toyota dealership. Brittany lived in Atlanta and worked in pharmaceutical sales. Both spoke to investigators after the arrest. Both used some version of the same phrase. They were not surprised. They had been waiting for years for the day a restaurant complaint stopped being a complaint and started being a charge. Texas Roadhouse is a casual dining chain founded in 1993 in Clarksville, Indiana, and headquartered in Louisville, Kentucky. As of 2024, the company operates more than 700 locations across the United States, including the franchise on Old Fort Parkway in Murfreesboro, which opened in 2009 and runs a staff of roughly 70 across 2 shifts. The restaurant seats 290 guests across a main dining room, a bar room, and a covered patio. On a Saturday evening in mid-August, the lobby wait routinely runs 90 minutes, and the kitchen plates close to 700 entrees between the hours of 5 and 10 p.m. The operation runs on a server bank of 18 tables per shift, a table turn average of 42 minutes, and a per-guest check average that hovers around $24. A ribeye, the 12-ounce cut Patricia ordered that evening, runs $26.99 on the printed menu. The complete appetizer basket, a 4-item sampler that includes fried pickles, cheese sticks, boneless wings, and rattlesnake bites, runs $18.99. With a sweet tea, a side salad, and a loaded baked potato, the pre-tax check on table 14 that night came to $89.41. The restaurant industry has a name for the maneuver Patricia attempted. They call it the half plate. It is a maneuver as old as the casual dining segment itself. A guest orders a meal. The guest consumes the majority of the meal. The guest then summons the manager and, with varying degrees of theater, reports that the meal was unacceptable from the first bite and demands the full check be voided. The maneuver relies on a single unspoken assumption. The restaurant will weigh the cost of a single voided check, somewhere between $40 and $90, against the reputational cost of a confrontation in a crowded dining room, and will quietly write the meal off. The math, in the vast majority of cases, favors the guest. Texas Roadhouse, like most national chains, maintains a written escalation protocol for exactly this situation. Offer a replacement. If declined, offer a partial discount. If declined again, present the bill and request payment. If refused, call the local sheriff. The protocol is printed in the manager training binder. The protocol is also, by design, the slowest path off the property. Most guests, when they hear the word deputy, pay the bill and leave. Patricia, that evening, did not. The ticket from table 14, time stamped at 6:47 p.m. on August 17, 2024, reads as follows. 1 complete appetizer basket, 1 12-ounce ribeye, medium rare, 1 loaded baked potato, 1 side house salad with ranch, 1 sweet tea, free refills. The server, a 23-year-old named Haley, would later tell investigators that Patricia had been polite during the ordering process, had asked one clarifying question about the rattlesnake bites, and had declined an offer of a glass of the house wine. The appetizer basket arrived at the table at 6:54 p.m. The ribeye, plated with the loaded potato and a small ramekin of butter, arrived at 7:11 p.m. For the next 34 minutes, Patricia ate. Haley passed the table twice to refill the sweet tea. The first refill came at 7:18 p.m. Patricia was eating fried pickles. The second refill came at 7:31 p.m. Patricia was approximately halfway through the ribeye. Haley would later describe Patricia's demeanor during this stretch as relaxed, friendly, and engaged. She asked Haley about the location's hours. She asked whether the rolls came with cinnamon butter. She complimented the loaded potato. At 7:45 p.m., Haley returned to the table to check on dessert. The ribeye, at that point, was reduced to a 4-ounce remnant on the right side of the plate. The appetizer basket was empty except for a small pile of pickle chips and a single rattlesnake bite. The baked potato was finished. The salad bowl was clean. It was at that moment, with the plate visibly 2/3 consumed, that Patricia set down her fork, folded her hands, and informed Haley that the steak was not what she had ordered, that it was overcooked and terrible, and that she would not be paying for it. Haley, trained for this exact situation, did not argue. She thanked Patricia for letting her know, removed the plate, and walked it directly to the kitchen pass where the manager on duty, a 31-year-old named Brandon Whitfield, was already standing because the host had radioed him about a guest at table 14. Brandon looked at the plate. 8 ounces of ribeye consumed, an empty appetizer basket, a cleaned salad bowl, a finished potato. He did not say anything. He picked up the plate, walked it to the kitchen camera, and photographed it on the stainless prep counter under the overhead light. The photograph, time stamped 7:46 p.m., would later be entered into evidence. Brandon approached the table at 7:48 p.m. He introduced himself, apologized that the steak had not met expectations, and offered to fire a replacement, any cut on the menu, on the house. Patricia declined. She did not want a replacement. She wanted the entire check voided. Brandon calmly explained that the company's policy permitted him to comp the steak in full, but not the appetizer basket, the potato, or the salad, all of which had been consumed without complaint. He offered, as a goodwill gesture, to take 50% off the entire bill, bringing the check to $44.71. Patricia refused. She wanted the whole thing voided. She wanted an apology in writing. She wanted Brandon's manager. She wanted a corporate phone number. Brandon, still calm, provided the corporate guest relations number, wrote it on the back of the check, and informed her that the 50% offer was the final offer, and that she would need to either accept it or pay the remaining balance. Then he walked back to the host stand and told the assistant manager to start the timer. 40 minutes. That was the company policy. 40 minutes from the moment a manager presented a final offer to the moment, if the guest had not paid, that local law enforcement would be called. The 40 minutes was not arbitrary. It had been calculated by a national operations team in consultation with corporate counsel as the window in which a reasonable guest would either accept the offer, escalate to a phone call with corporate, or simply leave. Past 40 minutes, the company's position was that the guest had crossed from disputed bill into theft of services. The clock started at 7:51 p.m. Patricia did not leave. She did not call corporate. She did not accept the 50%. She sat. She pulled out her phone and began scrolling. She ordered another sweet tea refill, which Haley, on Brandon's instruction, brought without comment. She made a phone call, audibly, to a friend, and narrated the situation in a voice loud enough for the 4 surrounding tables to hear. She used the phrase, "This is how they treat senior citizens in this town," 4 times in the first 10 minutes. At 8:11 p.m., 20 minutes into the 40-minute window, Brandon returned to the table and asked once more whether she would accept the 50% offer or pay the bill. Patricia told him to leave her alone. At 8:24 p.m., he asked again. She told him she was not going anywhere until she got what she came for. At 8:31 p.m., 40 minutes after the final offer had been presented, Brandon walked into his office, picked up the phone, and dialed the non-emergency line for the Rutherford County Sheriff's Office. The dispatcher logged the call at 8:33 p.m. A theft of services in progress at 2535 Old Fort Parkway. Manager on scene. No weapons, no injuries. Subject refusing to pay or leave. The closest unit, a deputy named Caleb Reyna, 6 years on the department, was finishing a traffic stop 2 miles east on Memorial Boulevard. He cleared the stop, advised dispatch he was en route, and pulled into the Texas Roadhouse parking lot at 8:41 p.m. He activated his body-worn camera as he stepped out of the vehicle. The timestamp on the footage that would later be played in court reads 20:41:17. If you are still with me, do me a favor. Drop a comment and tell me what you would have done at minute 30. Pay the half-off bill and walk out, or hold the line and wait for the deputy. There is no wrong answer. I just want to know how you read a room. And while you are down there, subscribe. We have got 2 more cases like this dropping this week. There was very little to investigate. That was the strange thing about the case. By the time Deputy Reyna walked through the front doors of the Texas Roadhouse, the evidence was already complete and already photographed. The ribeye remnant was bagged and labeled in the manager's office. The original ticket was printed and stapled to a written incident summary. The kitchen camera footage, time-stamped from 7:11 p.m. to 7:46 p.m., showed Patricia eating without interruption or distress for 34 minutes. The dining room camera showed Brandon's 2 return visits and Patricia's verbal refusals. The corporate guest relations line had no record of an inbound call from her phone number that evening or any evening prior. There was no allergic reaction. There was no complaint of illness. There was no claim that the steak had arrived cold or raw or marbled with anything other than what a ribeye is marbled with. There was only a plate, 2/3 eaten, and a guest who would not pay. That was the investigation. Deputy Reyna spent the first 6 minutes after his arrival in the manager's office, reviewing the kitchen camera footage and the dining room footage on a small monitor while Brandon walked him through the timeline. The deputy nodded twice. He asked one question, which was whether the guest had at any point claimed a medical issue. Brandon said no. The deputy asked if she had asked to speak to corporate. Brandon said she had been given the number and had not used it. The deputy looked at the ticket, looked at the photograph of the plate, and pulled up Tennessee Code Section 39-14-103 on his phone. Theft of services. A person commits theft of services who intentionally obtains services known to be provided for compensation by deception, fraud, coercion, false pretense, or any other means to avoid payment for the services. The statute had been on the books in some form since 1989. It covered hotels, it covered taxis, it covered restaurants, it covered specifically this exact circumstance. Deputy Reyna closed his phone, thanked Brandon, and walked from the manager's office into the dining room. The body camera footage from this point forward is what would be played in court. Patricia, still at table 14, was on her phone. Her sweet tea had been refilled a fourth time. The plate had been removed. The check, with a handwritten note from Brandon offering the 50% discount, sat folded on the table in front of her. The deputy approached at a measured pace, stopped roughly 4 feet from the booth, and introduced himself by name and rank. The footage runs 9 minutes and 41 seconds from the deputy's first word to the click of the handcuffs in the parking lot. It is not a complicated piece of video. It is, in many ways, a masterclass in the kind of slow, deliberate, professional calm that diffuses 99 out of 100 restaurant disputes. Patricia, in this case, was the 1 out of 100. Deputy Reyna. Ma'am, I am Deputy Reyna with the Rutherford County Sheriff's Office. The manager has asked me to come speak with you about the bill on this table. Can you tell me what is going on this evening? Patricia. I am being harassed. I am a paying customer, and I am being harassed because I complained about a steak. Deputy Reyna. I understand you have a concern about the food. I have spoken with the manager and reviewed the situation. The manager has offered you a 50% discount on the bill, which would bring the amount owed to $44.71. He has also offered to replace the steak with any other cut on the menu at no charge, and you declined that offer. Is that accurate? Patricia. I am not paying a dime. The food was inedible. Deputy Reyna. Ma'am, the food has been consumed. I have seen the photograph of the plate. 2/3 of the steak is gone. The appetizer basket is empty. The potato is finished. Under Tennessee law, when a person consumes a meal and then refuses to pay a reasonable bill, that can constitute theft of services. I am asking you to either pay the discounted amount of $44.71 or accept the manager's instruction to leave the property and resolve the dispute through corporate guest relations. Patricia. You work for me. I am a taxpayer. You work for me. You do not get to tell me to leave. Deputy Reyna. Ma'am, I work for the citizens of Rutherford County. That includes you. It also includes the business owner and the employees of this restaurant. My job tonight is to keep the peace and to enforce the law. The law says you cannot consume a meal and refuse to pay for it. I am asking you one more time. Will you pay the discounted amount or leave the property? Patricia slammed her open palm flat against the table. The body camera microphone picked up the impact. A small glass salt shaker, which had been sitting near the edge, tipped over the lip and shattered on the tile floor. A woman at the adjacent booth flinched and pulled her toddler closer. Patricia, undeterred, announced that she was going to live stream the encounter for what she called her followers, picked up her phone, and began recording. She held the phone toward the deputy and narrated for the imaginary audience. She said she was being illegally detained. She said the restaurant was committing fraud. She said the deputy was on the restaurant's payroll. Deputy Reyna did not respond to any of it. He waited. Then, while still holding the phone in her right hand, Patricia reached past the deputy with her left hand toward what she would later claim was a second phone on the table, and in the motion of reaching, her left forearm struck the deputy's right forearm with enough force that the body camera shifted on its mount. The contact lasted less than a second. It was, in the language of Tennessee Code Section 39 to the 13101, an intentional, unconsented touching of another person in a manner reasonably regarded as offensive or provocative. It was simple assault. The deputy stepped back, instructed her to stand up and place her hands behind her back, and when she refused, took her left wrist in a controlled hold and guided her to her feet. The handcuffs went on at 20, 48, 33. 16 minutes from the moment he had walked through the front doors. Patricia was still narrating to her phone, which was now lying face up on the table, broadcasting a view of the wood-grain ceiling, when Brandon, from a respectful distance behind the host stand, quietly picked up the bagged ribeye remnant and added a yellow sticky note that read, in blue ballpoint pen, the word exhibit and the letter A. Patricia Sue Galloway was booked into the Rutherford County Adult Detention Center on Lytle Street in Murfreesboro at 9:34 p.m. on August 17, 2024. The booking sheet listed 3 charges: theft of services under Tennessee Code, Section 39, Chapter 14's 103, a Class A misdemeanor given the under $500 value of the services; simple assault under Section 39 to 13101, a Class A misdemeanor; disorderly conduct under Section 39 to 17305, a Class C misdemeanor. The maximum exposure on the 3 charges, stacked, was just over 23 months in the county workhouse and a fine of up to $3,500. She was released the following morning on a $1,500 bond, posted by her son Travis, who had driven down from Knoxville overnight and who, according to the booking deputy, did not speak to his mother in the lobby on the way out. The case was assigned to Assistant District Attorney Lauren Mackey, a 6-year veteran of the 16th Judicial District. The discovery file, when it landed on her desk, was unusually thin and unusually complete. The kitchen camera footage, the dining room footage, the body camera footage, the ticket, the corporate policy binder, a written statement from Haley, a written statement from Brandon, a written statement from the assistant manager, and a written statement from a Mrs. Catherine Pollard, the woman from the adjacent booth whose toddler had flinched at the salt shaker, and, photographed under the fluorescent overhead light of the manager's office, the plate, the 8-ounce remnant of medium rare ribeye, the empty appetizer basket, the clean salad bowl, the finished baked potato. Mackey would later tell a local reporter, in a quote that ran on the front page of the Daily News Journal, that in 14 years of prosecuting cases in Rutherford County, she had never seen a defendant more thoroughly indicted by her own dinner. Patricia retained a private attorney, a Murfreesboro-based defense lawyer named Gerald Henley, who in the weeks leading up to her court date filed 3 motions. A motion to suppress the body camera footage, which was denied. A motion to dismiss the theft of services charge on the grounds that the dispute was a civil matter, which was denied. And a motion in limine to exclude any reference to her prior trespass from the Cracker Barrel and her removal from the Olive Garden, which was granted in part and denied in part. The case was set for a bench trial in General Sessions Court on November 14, 2024. The trial lasted 1 day. The state called 4 witnesses. Haley, the server, walked the court through the order and the consumption. Brandon, the manager, walked the court through the offers and the refusals. Mrs. Catherine Pollard described the slammed palm and the shattered salt shaker and the toddler. Deputy Reyna played the body camera footage from beginning to end and answered 6 questions on cross-examination, all of which he answered without raising his voice. The defense called Patricia. She testified that the steak was inedible. She testified that she had not struck the deputy. She testified that she was a taxpayer and a senior citizen and that she had been singled out. On cross-examination, ADA Mackey asked her one question. She asked Patricia whether she had eaten the steak. Patricia said she had taken a few bites. Mackey then introduced the photograph of the plate. The judge looked at the photograph for what the courtroom transcript records as 11 seconds. Then he looked at Patricia. Then he asked the bailiff to mark it as State's Exhibit 1. The verdict came back at 4:17 p.m. Guilty on theft of services, guilty on simple assault, guilty on disorderly conduct. The judge, in his sentencing remarks, was unusually direct. He said the case had taken a single day of court time and had cost the county somewhere between $4,000 and $5,000 in officer hours, prosecutor hours, court reporter time, and jail processing, and that all of it could have been avoided by the payment of $44.71 at 7:50 p.m. on August 17th. He said the defendant had every right to dispute a meal. He said the defendant had no right to consume the meal and then refuse to pay for it. He said the taxpayer argument, the one that had been raised in his courtroom roughly 30 times in his 15 years on the bench, had never once prevailed and would not prevail today. He sentenced her to 11 months and 29 days on the theft of services charge, suspended to 2 years of supervised probation, 6 months on the assault, suspended to run concurrent, 30 days on the disorderly conduct, suspended to run concurrent. Restitution of $44.71 to the Texas Roadhouse on Old Fort Parkway. Court costs of $1,284. A formal apology, in writing, to Deputy Reyna and to the staff of the restaurant, to be filed with the court within 30 days. And a permanent trespass from the Texas Roadhouse location, which the company had already issued in writing the morning after the arrest. Patricia paid the restitution by personal check on November 19, 2024. The check cleared. She filed the written apology 9 days later. The letter was 3 sentences long. It did not, according to the prosecutor, who reviewed it before it was entered into the file, contain the word sorry, but the judge accepted it. The Texas Roadhouse on Old Fort Parkway framed a copy of the front page of the Daily News Journal article and hung it in the manager's office, where it remains as of this writing. The ribeye remnant, after its turn as State's Exhibit 1, was finally permitted to be disposed of by court order on November 22nd. The corporate office in Louisville, Kentucky, sent the Murfreesboro location a single sheet of laminated paper to be added to the manager training binder. The sheet, titled simply Half Plate Protocol, walks new managers through every step of the August 17th encounter, beat by beat, from the first refusal to the deputy's arrival. At the bottom of the sheet, in bold print, is a single sentence. Call the sheriff at minute 40. Patricia Galloway, who turned 62 in May of 2025, remains on probation until November of 2026. She has not, in the months since, returned to a casual dining restaurant in Rutherford County. The restaurants, by all accounts, are doing fine without her. This case was something else. But the one on the right-hand side, the one playing on your screen right now, is the kind of restaurant meltdown that makes this one look like a customer service training video. Click it.